What's up? Order in the court. They wrote me and they said, and you already know what time it is, y'all. I'm sorry. Order in the court. It's your favorite attorney, Attorney Allie Booker, where I bring you to the court of my public opinion. You write me via email, booker@bookerlawfirm.com. I bring you to my show, to the court of my public opinion. I let you know what's up. Now, you can't call this illegal advice because I don't represent you per se, but I'm going to take what you give me, okay? And I'm going to give you the best response possible. I'm going to be straight up and candid because that's the type of attorney that I am, okay? I don't sugarcoat much of nothing. We don't got time to go into court looking like damn fools. So we're going to get together right here and right now. Without further ado, let's get it crack-a-lacking. They wrote me and they said, will the beneficiaries of a non-custodial parent who owes child support arrears be responsible for his debt upon death? My dad owed child support arrears in the state of Texas where paternity was never officially established, only awarded upon default judgment due to him missing a court date because he was working out of state. In addition, the child's 26. He's never spent time with the child. The child does not know who his father is, and the custodial parent has prohibited contact with him at all costs. The question is, my dad has life insurance policy with his known children listed as the beneficiaries. Would we as his children be responsible for paying his child support arrears upon his death? Is it possible the state of Texas would intercept the life insurance? Or is it not considered to be part of an estate? Please help. Okay, y'all, let's start off. I have had cases, y'all, and, everybody, how do I say this nicely? Baby, you ain't the only child. That's it. At the end of the day, you can make up all these excuses why your daddy didn't legitimize and all this other stuff and didn't show up at court and all this other mess that you want to say. But he has another child out here. And the adjudication doesn't go away, or it's not less than just because it was by default. If he wanted to fix that, honey, he could have fixed it. He did not want to fix it. And let's just call a spade a spade. I've had plenty of cases where the kids got mad at me. I even got off of the case because we wasn't getting along no more. Because at the end of the day, I'm not finna sit up here and keep this beneficiary away from here. If we do a DNA test and that's your sibling, then that's your sibling and he gets his just amount. It doesn't matter whether he's in jail, if he's just gonna squander it away. It does not matter. At the end of the day, your daddy has somebody else that he fathered, and that child is due whatever you all are due under the will, and that's just the law. Again, there are paternity tests that can be had if you want to challenge this individual, but at the end of the day, there's a court order, so it's nothing you can do about it. It's a court order, it's valid. If you want to argue and say, you want to challenge that, DNA test gonna prove probably that that's his child, but you probably not gonna get the DNA test because I'm sure there's a court award. The only time where you can't understand that there's a court award or something along those lines is if nobody can produce the court paperwork because it's so old, like from the 70s. People can't find it. Nobody goes to bring it to court. The short way is to do a DNA test and not worry about it. And that actually happened in the case that I had. And he was the child, and they was mad. And it was child support, back arrears. And at the end of the day, the estate was responsible for that. Now, as far as any insurance policies, if he has your names listed, since he found out he was the father of that child and he listed beneficiaries, it's fine. But if those are old beneficiaries from another marriage or from before he had other children and things of that nature, the insurance company is going to make it go through probate because it's old. And the thought process is if somebody puts their children as beneficiaries and they have more children, those new children are to be added. Sorry. So I don't know what the verbiage is on the beneficiary list or how he listed it, but if he listed it as his children, they're going to get a piece of the pie. That's it. And any other estate that you have out there that's liquid or that a lien can be put on, yes, child support will come and put a lien on it. Child support will come put a lien on the house, whatever they can put a lien on. Yes, ma'am. And you will have to pay that money regardless of the fact that he's 26. His mother is still owed. I have seen child support come in for 50-year-olds, 40-year-olds, okay? And that's what happens. And down here in Texas, it does not go away. You can be jailed for child support. That's how serious it is. So, yes, ma'am, whatever liquid assets or whatever assets the estate has, they will have to pay that child support back first. And, yes, depending on how that child is listed in the beneficiary list or how the man has his beneficiaries listed, he may be getting a piece of the pie of the life insurance as well. That's a part of being a father. You pay child support and you list your children in life insurance. I don't know what the problem is. Next case. Don't know what the problem is.
Biggest time I made that call. I'm locked up and facing charges. Who gon' fight these cases for me? I call Booker Law Firm. They done, they were right there for me.
For more information, contact the Booker Law Firm at 713-292-2225.